And if you want to share your views on the subject we are discussing in public forum this evening, you can call us on our toll-free numbers that are 1800115313 and 1800115314. We'll continue the discussion with H.S. Phoolka. Mr. Phoolka, I'd like you to respond to what Professor Sinha said earlier in the program, that the bill proposes to set up a national authority for communal harmony, justice and reparation. But what the composition of this body is something that seems to be the problem.
The composition is totally justified, I would say. Now let's see, these three major violences have taken place. In Delhi, it was the Sikhs, which is the minority community. In Mumbai, it was the Muslim, which is the minority community. In Gujarat, it was majority Muslims. There has been killing of Hindus as well. But most of it, it's the minority community which have been the target. Who are the victims? Who are the victims? Now the purpose of this national authority is to instill confidence in the victims. When the victims are this minority communities, it is therefore that in the composition of this national authority, it's been said that out of the 7 members, there are 7 members, out of those 7 members, 4 would be belonging to these this group, this and this. So I don't think anything, because this is to instill the confidence in the victim community. That is the purpose.
Fair enough.
And moreover, whenever a person sit over there, a person, when he will be responsible people, they will not be sitting as a representative of their community. They will be sitting there as the person who is to decide, who will be taking a decision on the basis of the law.
Right. All right. Coming to the hate speech part of it, Mr. Madhavan, this bill also recognizes hate speech as something that incites communal violence. Do you think the definition here is...
Hate speech itself definition is not particularly problematic, because it actually says that it's hate speech only if it causes a clear and present danger.
Okay.
So that's to a person. So it in some sense restricts the definition. But there are several other aspects where it in some sense reverses our basic concept of criminal justice system. Okay, I'll just come to that. Firstly, it actually says that the burden of proof is reversed in several this thing. Section 74 says, if in a prosecution for any offences committed under this act, it is shown that the accused committed or abetted or conspired to commit the offence of hate propaganda, it shall be presumed, unless the contrary is proved, that the offence committed was knowingly directed against a person.
Okay.
Now, basis of criminal justice system is, we are prosecuting and we have prosecuted Ajmal Kasam. He was considered innocent until he was proven guilty. So we should not get away from such basic concepts for these things. It would be my position. A second thing is they have actually included and given the powers of phone tapping to the authorities. I mean, that to me is again problematic, because we are living in a liberal democracy presumably, and phone tapping today is under extremely rare circumstances. Home Secretary of the center of the state has to authorize, and only then it can be done. It cannot be used for various other purposes. It cannot be sanctioned by anybody else. I would like to have such protections against misuse by the authorities under some other guise like this. Another section for prosecutions and various this thing, they are saying of public officials, sanction is not required. Now that is a questionable thing, in the sense, there are of course lots of cases where the government does not provide sanction and the person is protected. Fine. You want to get rid of that? Let's have a discussion on, should we have the provision of sanction under the IPC itself? Should we remove from there? It should not be restricted to communal violence cases sanction.
What does one do when the state itself is complicit?
So let's have a discussion about how do we handle sanction for prosecuting public officials under various cases, IPC, corruption here. Let's not take communal violence and make a special law for that. Let's have a generalized discussion. Figure out as a country how are we going to treat this particular issue. Have that uniformly across laws. So what I don't like is a specific laws having these pockets of discretion.
All right.
Now, if I may respond. Now, first of all, this section 74 presumption. This is not a presumption like in TADA. In TADA, moment a person is charged, he is presumed guilty, it's his responsibility to prove that he is innocent. It's not like that. It says that if he is proved, if guilt is proved, if he is proved that he has committed the offence, then after that it will be presumed that it is out of the hatred. But first the proof is to be proved that he has committed the offence. Like a person has killed. First it to prove that he has killed. Then after that the presumption will arise. That is for the purpose of the sentence. It's the presumption is not for.
But it's a higher sentence here.
No, that's right. Only
So-
for the purpose of the sentence, not for the purpose of conviction as such. So therefore, it is not that the moment he is charged. Okay. So it is not like Tata. Number one. Number two, sanction. Now, in case of sanction, for 153A that a person is spreading the criminal hatred, enmity between two communities. Now, a sanction of the government is necessary. Now, we have seen in the case of 84 rats against Sajjan Kumar, the government did not give this sanction for 4 years. The CBI prepared the charge sheet from 1990, almost 1991, and till this happened in 1994. For when the hue and cry was made in the parliament, the Madanlal Khurana came as the chief minister, he made a lot of hue and cry, and it is ultimately after that the sanction was given. So now this provision it is such a draconian provision which says even to charge anybody for spreading criminal enmity, you need the permission of the center. And in this case, which is going against Sajjan Kumar, in this case, the CBI prepares the charge sheet on the basis of the recommendation of the Nanavati Commission. CBI sent it to the Delhi government, and Delhi government police and their law department says sanction should not be given. And it is when the
so why don't we
hue and cry was made.
Provision.
So it is because of that reason.
So why don't we amend the
Then
IPC?
why
No,
don't
but
we insulate our investigating agencies then
the
from...
point is this, it is that sanction for like this 153. Why sanction? When a person is charged for spreading the hatred between two communities, why sanction of the government?
Okay.
If the government agency who are charged, it is to tackle
No,
that.
I don't have a disagreement with that, but then let's amend IPC. I mean, if that is the decision, why are we creating these silos of laws?
This virtually means that only.
No.
Instead of bringing...
It will be simpler.
No.
It will be cleaner.
Madhavan Sahab, instead of bringing 2, 3, 4 laws, so this is virtually that only.
No, you are bringing
All
a
right.
new law, right? Instead of
Professor Sinha,
amending
I'll
the
take
system.
your views also, but right now we are joined by a caller, Dabbu Joshi from Uttarakhand. Welcome to the program. What's your question?
हाँ जी धन्यवाद नमस्कार। देखिए मैं अपनी बात हिंदी में रखते हुए चाहूंगा कि आप अंग्रेजी में अपनी बात जारी रखें। देखिए सांप्रदायिक समस्याएं तब तक समाप्त नहीं होंगी जब तक इन्हें रोकने हेतु कोई भी कानून भी तब तक प्रभावी नहीं हो सकता जब तक कि हमारा राजनीतिक चिंतन वोट बैंक की राजनीति से ऊपर का ना हो जाए, क्योंकि इतिहास गवाह है कि सांप्रदायिक ताकि आपको सुलझाने का काम हमेशा नेताओं की राजनीति नहीं किया है। इसलिए इस मंच पर विराजमान विद्वान साथियों के माध्यम से मैं देश के गणमान्य नेताओं तथा उनके घरानों से एक जिम्मेदार समाज के कार्यकर्ता होने के नाते पूछना चाहता हूं कि कब आप सांप्रदायिक राजनीति से ऊपर राष्ट्रीय राजनीति करना आरंभ कर देंगे, जिससे कि फिर हमें कम्युनल वायलेंस जैसे बिलों की आवश्यकता ही न रह जाएगी। बहुत बहुत धन्यवाद।
All right, Mr. Phoolka, would you like to comment on that?
No, he is right. That we have to look into the national interest, and this is what precisely I tell you, that the need of this bill is very much for this purpose only. That you need to look into the national interest, and you need to realize this thing and recognize this thing, that each and every citizen of this country need to be protected.
Right.
He needs the protection,
and deserves
even if he
justice.
is one man against 1 lakh.
All right.
I think
Technical
this is
problem.
Sure, Professor Sinha.
what he raised the question that vote bank politics. I think the hidden agenda of the bill is to polarize the minority community by the establishment.
Okay.
I will give you 2 examples, which is a very sensitive thing. The clause 10 of the bill says the financial assistance to any organization. Suppose I have been caught for some guilt, whether it is right or wrong, and I am being alleged that I am torturing or doing something wrong with the so-called the members of the group. The organization which I belong and the people who are funding to the organizations, they will also be punished, and the criminal procedure code would be applicable to them. Now, nobody would like to fund any Hindu organization, because suppose you cannot take guarantee of all the organization, all the members of the organization, that they will act very judicious and in a secular manner. So all the Hindu organization will be now fundless organization. No, people will say we are sympathetic to you, we will not fund you. Number 1. Number 2, this bill is parallel to a law made by the Nazi Germany. 1933, Nazi Germany made a law for the bureaucrats and the police. They had presumption that these police and bureaucracy are sympathetic to Jews, so to cleansing that mindset, They should be more judicious. So they brought under the national one authority, and they have imposed certain conditions to act in the Germany. This law also presumes that, this proposed bill also presumes that bureaucrats and the police acts in a biased, partial manner, and they are against the minority community. Always they are against the minority community. And on this presumption, they are imposing certain conditions which will make very difficult for a police officer or a bureaucrat to function in any condition. But suppose communal rights takes place in, you just see there are 5 to 6 cities where communal rights take place, not all over the India. So India cannot be victim of the 2002 rights or a 1984 rights. We have to go ahead. These were unfortunate. We have to look out the certain means and mechanisms.
But Professor Sinha, these were unfortunate incidents, but have we provided justice to the victims?
But that is the point. He's right. He's making a very judicious point that Sajjan Kumar and all other victims, who were the guilty for that, they are moving freely, and the victims are just roaming from here to there for the compensation. That is not the problem. Problem is that this bill is creating a situation where the police and the bureaucrats cannot function in a judicious manner. You cannot blame entire judiciary, you cannot blame entire police or entire segment of law and order
But the part of the judiciary comes much later.
They are the biased. Indian state is not functioning as a Hindu majoritarian state. Indian state is a secular state, and this bill is blaming the Indian state.
Okay, we'll talk more on the role of the police and the administrative machinery at large after this quick break. Stay with us for the final segment of the program. The discussion continues. This bill and the draft that has been prepared by the National Advisory Council. With H.S. Phoolka. Mr. Phoolka, post-independence, India has seen many caste and communal conflagrations, and the worst of them have occurred in the last 30 years, be it the 84 riots, the Mumbai riots of 93, Godhra of 2002, or even the Kandhamal violence. And in each case, the state has been charged with complicity, and in elections we see that the political party in power never had to pay the price for it. What do you think is the reason?
Now, this is what the vote bank politics. This is being said that the vote bank politics is to please the minorities. No, this is absolutely wrong. The vote bank politics is being played by the parties who actually commit this violence. You see, in the case of 1984, the 1984, after the violence, such a hatred was propaganda was made against the Sikhs, that Sikhs are anti-national. When the posters of Sikhs were said, "Can you trust this man?" And I admire, at that time it was Mr. Bajpai who came forward to in fact in the defense of the Sikhs, and he said, even if we do not win even a single seat, but we want at least to save this nation. This is when, and at Congress won by 3rd, 4th majority on the basis of that violence. See in Mumbai, Shiv Sena won after the Mumbai violence. See in Gujarat, Mr. Bajpai again took a stand in Gujarat in 2002. Again, the BJP won the next elections. Who is playing the vote bank politics? The parties who actually commit this violence, who kill these people, they are doing it for the purpose of vote bank politics, and that is need to be stopped. Vote bank politics is not to give a security to a citizen. That's not a political politics. It is your duty. It is the duty of each and every political party, and they need to realize it. If they want to give a kind of a feeling, a security to each and every citizen, this is their duty. It's not any kind of politics.
All right. Mr. Madhavan, coming to the technical parts of the bill, what are the other objections or other loopholes that you see?
Some definitions themselves. See, I'll actually go back to IPC in the sense, I'm not a lawyer, but I've read these to some extent, and it's such a beautifully crafted document. Simple English, illustrations well defined. And in any law, your definitions and examples have to be extremely accurate so that the court and the judges know what the legislature wanted. Now I'll just give you some examples. Communal and targeted violence. It says that it is anything, that any act which results in injury, etc., which destroys the secular fabric of the nation. How do you expect a judge to decide whether a particular act actually is destroying the secular fabric or not? So we need precise definitions.
Okay.
Again, if I get down to the definition of hostile environment, the last part. Hostile environment is anything that has a purpose or effect of creating an intimidating, hostile or offensive environment. So hostile environment is something that causes hostile environment. That's what it says. What does that mean? It means nothing.
Okay.
So we need to tighten this. That's one. And just to, on a lighter vein, there is a particular post which when I saw, I had certain images in my mind. Every district will have certain people who are called the human rights defender for justice and reparation, which as soon as I read this, I thought of Batman or Superman or somebody, because it's so,
With superhuman
like
powers.
it's like a comic strip character, right? Human rights defender for justice.
I will intervene here.
Just if I can help. In this internationally known term, defenders. Human rights defenders are the people who are actually working for the cause of human rights. So it's an internationally known term of human rights defenders.
Instead of going
in our law it is not there,
All
but
right.
in the foreign laws it's there.
Okay.
What I believe, instead of going in technicalities, we should go by the spirit of why they framed this law, for the bill. One thing is repercussion. What in the present form it becomes the law. You look, the Hindu, Muslim, Sikh, and Christian. Everybody is acting economic interdependence. In the city of Meerut, the Hindus are doing one job and Muslims are doing other job. They are interdependent. The lock industry you see, the Banarsi sari you see. This bill is going to end the interdependence of the religious communities.
But this is also a place where we see communal violence flaring up.
There is no two opinion that communal violence should be prevented, and the law, there is a need, IPC, CRPC, if you need a law to make a law. But this law is giving honors for the communal violence on the Hindu community. It is the majority which
No, Professor Sinha, what this bill seeks to do is to put in place mechanisms that are going to eliminate the institutional bias that exists.
There is no institutional bias. There is a National
discussion.
Commission for Minority. I am just giving that. There is National Commission for Minority. In 2003 and 4, there were 3,578 complaints to National Commission for Minority, in which it found hardly few hundred complaints, genuine complaints. Only 2.7% complaints were on the law and order question. There are institutions, National Commission of Minority. You are creating institutions.
But Professor Sinha, what are the chances that if a person from a minority or a supposedly distressed minority goes to a police station, the complaint will be filed or the person will be heard out?
No. If things happens, if certain exceptional cases happens, they should be tackled, and it is the law and order situation, and the rule of law should be always applicable.
Okay.
My thing is that this bill gives honors to the majority community. It defines the communal rights. The communal rights means the attack on the group by the majority. If the similar thing happens, the attack by the so-called the minority community on the so-called majority community, that is not the communal rights according to this bill. This bill is a very divisive. This destroys the secularism.
In the beginning we said the group need to be redefined.
So let's
go ahead after
Go ahead. Let's
go ahead after.
I
Very
had one
quickly.
question which I wanted to ask.
Universal application.
Sure,
Phoolka
go
as an advocate, which is, if you see section 86,
Yes.
it actually talks about rights of victims.
Yes.
And the victim shall have the right to apply to the court to summon parties, victim shall be entitled to be heard at proceedings, etc. And usually in any criminal justice, the crime is supposed to have been done against the state, against society, and it's the state versus the accused.
The CRPC is amended, the victim has been given the right in the CRPC.
Yes. So
it is akin with that. I mean, now earlier it is only the police and the prosecution who will pursue the case. The complainant has absolutely no right. Whatever the PP may say, whatever the IO may say, complainant has no right at all.
But Mr. Phoolka,
now-
just clear
but
it.
now-
Just one
now
point,
the
one
CRPC.
clarification I want.
Sir.
Ki, according to the present state of the bill, who is the victim? Who is the victim?
The victim after the redefinition.
No, after this bill.
I myself, I am telling you that it need to be relooked.
No.
Universal application.
We are discussing
In
this,
this-
Mr. Phoolka. There will be confusion among the
You see,
listeners.
in this forum, it is only the linguistic or religious minority.
They are the victim.
But now, now I tell you, after the
if Hindus are killed,
No,
they are not
only-
the victim. Hindus are homeless, they are not the
No, that-
victim.
now,
but we decide to go ahead with
We
that.
decide to go ahead.
We are stuck in that.
Sinha,
We are never good to
We
other points.
must
Everybody is
we must
saying-
we must condemn the present
No, you see,
form of the
I
bill.
am not.
It is not that. It is the
I am not at
philosophy.
all. I am not at all speaking for the NSC or the drafting committee or the advisory committee at all. I am just happen to be one of the members, and I have conveyed my views to them.
Okay.
But I am of the view that the definition of the group need to be
That's fine.
relooked, and this should be made a universal application.
Very quickly, Professor Sinha, my final question to you: wouldn't you agree that whenever communal violence takes place, it is usually the minority communities or the Dalits that have to bear the brunt, and that there is an institutional bias against them?
Instead of giving my own opinion, I am just quoting P. Jagan Mohan Reddy report in 1969 on communal rights in Ahmedabad. He says both the communities have to take the blame, irrespective of the blame of the culpability of any community concerned. If you, for the immediate violence, you can blame any community or any individual. But it is both the community, it is the socio-economic complex situation which creates riots in certain cities, certain places. Why not there is a riots in Bareilly? Why not there is a riot in other places? Why only Meerut and Aligarh? Why in Mumbai and Delhi? So these are the things which must be looked into. And I believe that in a secular democracy, the makers of such bill, they must be brought to the book.
Okay.
They have done a great injustice to the society and secularism and the secular tradition of this country.
Okay, well,
we are living in an inclusive society. We are not living in the exclusive society.
We're completely out of time. I'd like your final comments, but starting with you, Mr. Phoolka, do you think we need such a legislation in the first place, and is it going to change things for rights?
First of all, this is not even a bill yet. This is only a draft.
Right.
When cabinet, it will become a bill when cabinet approves it. It is introduced in the parliament, then it is. So it is only a draft which is given by the NSC. And everybody is saying that it needs to be relooked, it needs to be redefined, but it is absolutely necessary.
Okay.
There has been a long wait since 2005, it has been pending, and now we need to do it, make whatever the changes are necessary and pass it. That is what I want.
All right, so it's been a long wait, it's absolutely necessary. Professor Sinha, your views?
I think in the present form, this bill needs to be burnt. There are certain proposed bill which need to be thrown into the dustbin, but this bill is destroying the secular fabric of the secular fabric of the country. This bill is destroying the unity, the Jawaharlal Nehru's concept, unity in diversity.
Okay.
This bill is creating a permanent hatred between the majority and minority. So this bill in the present form need to be burnt.
All right, Mr. Madhavana.
We can't get away from the fact that riots happen in our country. So the issue is, how do you prevent riots, one? Secondly, in case they happen despite your prevention mechanisms, how do you make sure that the people who are perpetrating the riots, regardless of whoever they are brought to book? And third, how do you take care of the victims? So you do need to figure out either a law or a set of laws or a system to make sure that we do these. And I hope that whatever this has started goes in, addresses those issues, and finally we get something out of it.
At least we three agree that the concept of group should be relooked, and
Sure.
basically that should be dropped.
All right, and of course there are several suggestions from all of you that need or that could be incorporated into the final draft of the bill. On that note, we'll have to wrap up this discussion. I'd like to thank all my guests for coming to our studios. It was a pleasure having you all here. That's it for now in this edition of Public Forum. Thanks for watching. Goodbye.